Okay, so let me just lay this out. Tyler Robinson is accused of assassinating Charlie Kirk. Full stop. That's a horrific act. And if he did it, he should face the full weight of the justice system. But here's the thing. The same DOJ that can't produce 1% of the Epstein files in 5 months is now running this prosecution. And the defense just stood up in court and said, the FBI generated raw DNA data files back in September. We've been asking for them for months. The state won't hand them over, won't even say why. Watch defense attorney Mr. Novak walk through this. Calm, surgical, no theatrics. He's not asking for the moon, he's asking for a date. When are we getting the files? And the prosecution can't even answer that. Hit subscribe before the clip rolls so you don't miss the breakdown after, because what's happening in this courtroom tells you everything about how Pam Bondi's DOJ operates when nobody's looking. Let's watch.
Under Daubert, under 702, we're talking about a core data file. It's literally a data file, one from the ATF and one from the FBI, that they generated back in September that hasn't been provided to us. So we can't provide that to our experts to help us assess whether or not there are reliability problems with the reports that the state wants to offer through 1102b4. So we're not talking about the slippery slope and months of litigation of Daubert-type expert notice. Mr. McBride is right that at a certain time and place there will be discovery litigation related to experts and then admissibility litigation related to experts. That's not what we're talking about here. We're talking about very concrete data files that our experts are waiting for. And when I say data files, I literally mean the digitization of physical evidence obtained from our client and from these objects. We didn't choose for the state to present DNA evidence at the prelim. That's their choice. And that's why we are having this dispute right now. The question that I think this court needs to also address is when Mr. McBride talks about what discovery is, quote, reasonably available to the prosecution. How can this court conclude that not having these data files is reasonable, given that the ATF and the FBI generated these data files from the swabs months ago? They've concluded their work. As far as we know, they've generated reports. The state believes that the reports are sufficiently final that they would offer them into evidence in a preliminary hearing. So I think this court should make the finding that those reports are reasonably available and that they should be produced to us. Mr. McBride, probably because he can't, still hasn't told the court why we don't have the data files. So where Mr. McBride, with all due respect to his advocacy, because he's a fantastic advocate, goes, is he goes into the slippery slope of expert discovery and expert notice and Daubert, and that's really not what we're talking about here. We're also not talking about the bullet fragment further testing issue, which has previously been described as the January 9th motion, which the court unsealed. That is not a DNA issue. That is about what happens to a bullet fragment when a federal law enforcement lab wants to do what they call destructive testing. It's not to get DNA off of it. It's to look at whether that bullet fragment can be related to the other evidence in the case, because the ATF's first conclusion, as the court knows, is that they couldn't say either way where that bullet fragment came from in terms of firearms. So that is not what we're talking about here. There is a ballistics report that the state wants to offer into evidence at the prelim, but we're talking about DNA reports. And I do want to say, however, that we are not suggesting that the preliminary hearing be postponed until this dispute about the destructive testing of this bullet fragment is resolved, but it was a federal law enforcement lab that said, we're not going to permit a defense expert to observe the destructive testing, and we're not going to videotape the destructive testing. We're going to do this behind closed doors. But that's not what we're talking about here today. That's a different issue for a different time. And I don't think it has anything to do with when the preliminary hearing occurs.
Mr. Novak, just to be consistent, do you have some final thoughts as your time is coming to a close?
Yes, thank you. My final thought is that this court should direct the state attorneys to find out when the data files will be produced. And once we know that date, and they actually are produced, then we've already told the court that there's a concrete.
All right. So let's talk about what just happened, because Novak did something really important here, and I want to make sure you caught it. He drew a line. On one side, you've got the legitimate, complicated discovery fights, expert notice, Daubert hearings, admissibility battles. That stuff takes months. Everyone agrees. On the other side, you've got a data file. Just a file. Already generated. Already finished. Sitting on a hard drive somewhere at the FBI. And the state won't hand it over and won't say why. Here's what's on your screen. The defense is formally accusing the state of withholding raw, digitized DNA data that the FBI and ATF generated months ago. The prosecution gave them final summary reports, the conclusions, but not the underlying files those conclusions were built on. And without that raw data, defense experts literally cannot verify whether the state's analysis is reliable. It's like being handed a graded test with no answer key, no questions, just the grade. Trust us, we got it right. That's the prosecution's position. Trust us. Under this DOJ, trust us, and here's the part that should bother you, regardless of what you think about Charlie Kirk or Tyler Robinson. The legal standard is whether the evidence is reasonably available to the prosecution. Novak's point is, it's devastating. The FBI generated these files, they finished the work, they wrote final reports based on the files. The state thinks those reports are final enough to enter into evidence at a preliminary hearing. So how exactly are the underlying files not reasonably available? You can't have it both ways. Either the work is done or it isn't. Now, this next one is where it gets really uncomfortable. There's a separate fight happening over a bullet fragment. The ATF originally couldn't determine whether it matched the alleged firearm. So now a federal lab wants to do what they call destructive testing, which alters or destroys the evidence in the process. And the lab said, no defense expert in the room, no video recording. We'll do this behind closed doors, and you'll just have to take our word for it. That is the actual position of a federal law enforcement lab in the most high-profile prosecution in the country. Let that sink in. They're going to permanently alter physical evidence in a capital murder case, and they refuse to let the defense watch or even film it. And look, I want zero sympathy for what Robinson is accused of doing. None. But if a federal lab under this administration can destroy evidence in secret on this case, the most watched case in America, what do you think they're doing in cases nobody's covering? In immigration courts? In federal drug prosecutions? When the cameras aren't rolling? That's not a hypothetical. That's the question. And what's on screen now is the bigger pattern, and this is the part the channel's been tracking for months. This isn't one isolated dispute. The defense has been in court repeatedly, fighting for basic discovery materials, expert notices, Daubert challenges, admissibility of preliminary evidence. Every single one of these turning into trench warfare. In a normal case, this stuff is routine. The prosecution hands it over, both sides prep, court moves forward. Here, the defense has to litigate for every scrap. That's not how a clean prosecution operates. That's how a prosecution operates when the people running it know the evidence won't hold up to scrutiny. And look at the asymmetry. The prosecution is happy to use the DNA evidence at the prelim. They chose to put it on the table. They're not saying we're not ready. They're saying we're ready enough to use this against him, but not ready enough to show you how we got there. You don't get to do both. If the report is final enough to convict with, the data is final enough to share. period. So here's the line. Tyler Robinson is accused of a horrific act and deserves a real trial, not a rigged one. Because a rigged conviction is a conviction that gets overturned. The state is using DNA to prosecute him while refusing to turn over the raw data behind it. A federal lab wants to destroy ballistics evidence with no defense observer and no camera in the room. And this is the same DOJ that's been stonewalling Congress on Epstein for 5 months. If they'll do it there, they'll do it here. If you want straight coverage of what this DOJ is actually doing, hit subscribe and the bell. Share this with someone who needs to see it. I'm Donald Taylor. I'll see you in the next one.